Welcome to Litigation Nation. I'm your host, Jack Sanker, along with Danessa Watkins. Remember, this is the show where we get you up to date on the most important and interesting legal developments. You can find us on Apple Podcasts, Spotify, YouTube, wherever you get your shows. Danessa, what do we have this week?
All right, Jack. Well, first I have a story out of New York where a jury just awarded a woman $30 million against her ex-boyfriend for violations of New York City's administrative code against revenge porn. And then we have a decision out of the U.S. Supreme Court, or SCOTUS. It was a unanimous decision that states cannot remove candidates from the presidential ballot. However, when the decision was released, they forgot to scrub the metadata, which revealed that the opinion maybe was not unanimous to begin with.
And I'm going to be covering a cyber attack in Fulton County, Georgia, which threatens to release a lot of private sealed court documents that are being used in a number of different cases, but most importantly, the Trump election case, which is ongoing, which is of course going to have political ramifications, but of course could affect the trial itself. All of that and more, here's what you need to know.
All right, so starting with our revenge porn case. In late February of 2024, we have a jury that awarded a SUNY, that's City University of New York, public health professor, $30 million against her ex-boyfriend. Now, we use this term revenge porn, but it really means non-consensual pornography. So the distribution of intimate images without a person's consent. And even though it's usually these revenge-motivated cases that hit the news, that's certainly not always the case. There could be situations where one partner just wants to brag about how attractive their current partner is, so they post these nude images online. And as you know, once things are online, it's hard to get them down, and within seconds they can be shared. So that's just kind of some background on what revenge porn is. Now, looking back to our story, the plaintiff here is Dr. Spring Chenoa Cooper. And for about a year, she dated a man, Ryan Bromes. He's a comedian from Brooklyn. And the couple split when Dr. Spring allegedly learned that Bromes was actively engaging in affairs with other women. So she broke things off. She blocked her ex-boyfriend on social media. And then soon after, Bromes began posting nude photos of her online. Typically, he was using usernames that hid who the publisher was, but it was pretty easy for Dr. Spring to figure it out because she had only shared those images with her boyfriend at the time they were dating. Now, she did try to get a protective order initially, but that did not actually stop him from posting. He was not only posting nude photos, but also videos of himself mocking her and the restraining order that she had gotten. And he did this both on social media and on platforms where he was able to link to her work website, posting her name, her face, and all of her contact information. So as you can understand, this is certainly creating a dangerous situation for Dr. Spring. She had hundreds of men harassing her on social media. She also had to use security to get to and from work because people were tracking her down. So when the restraining order didn't work, she looked to both the state law and New York actually at the time, and still does, has an administrative code that was actually stronger back in 2018 than the state code for providing the type of relief she was seeking in civil court for revenge porn. Now, at the same time, there was a criminal investigation and eventually a prosecution that was going on. And in 2021, Bromes pled guilty to the misdemeanor of disclosure of intimate images. However, he didn't receive a jail sentence, and he was forced to attend a program for abusive partners. It ultimately didn't give Dr. Spring the relief that she was looking for under the revenge porn statutes. So 6 years after she filed this initial lawsuit is when the case finally went to a jury. By that time, as I said, Bromes had already pled guilty, so there really was no issue on liability. The judge found him liable, so the jury really only had to determine the amount of damages. This $30 million award was the greatest award that New York had seen under this statute, and Dr. Cooper says she certainly doesn't expect to collect, but...
Yeah, he's a comedian,
Yeah,
right?
exactly. But for her, it was more about sending this message of deterrence and showing that there is relief available for victims, and hopefully deterring these crazy ex-boyfriends and probably ex-girlfriends too from pursuing this type of action against their former partners.
Well, she will be able to, garner this guy's wages for the foreseeable future, several thousand years probably. So, I mean, hopefully she does get some financial relief out of this. And Danessa, I think, if I'm correct here, you have some exposure to this area kind of in your personal practice?
Yeah, so my practice group here, we have had a few of these cyberbullying, revenge porn type cases. One of our more recent ones, actually, we brought alternative claims to revenge porn. We also filed under defamation, false light invasion of privacy, tortious interference with business expectancy. This was kind of a crazy case where we had a client who his ex-girlfriend was sending nude photos to his place of work. So it kind of took it to another level for him in that his job and his clients, they were getting targeted with these images of him that obviously didn't paint him in the best light. Yeah. And she was also accusing him of rape. So yeah, and it was the same thing. By the time it got to trial level, she had already been prosecuted criminally and been extradited back to her home state. So it was really just an issue of damages. But the important thing that you can get from that case is that there are ways to pursue an action for this type of revenge porn, even if your state doesn't have a statute specific to it, or if the statute does not allow for a civil lawsuit. There are these type of emotional distress or invasion of privacy claims that you can bring. But currently, 48 states have some form of a revenge porn statute, the two holdouts being Massachusetts. I did look up, though, that the House actually just unanimously passed pending legislation, so hopefully Massachusetts will be passing something soon, but South Carolina is the other holdout, and I did not see anything currently on their books of them trying to pass something. But the other available avenue potentially is at the federal level. There is the Violence Against Women Act, Reauthorization Act of 2022. That was passed in March of 2022.
So I do not practice in this area, so I'm going to throw something out there and you tell me how right or wrong I have this. My understanding is that these, at the state level and now at the federal level, the legislation that is dealing with what we're calling revenge porn, but broadly encompasses a lot of other things, are relatively new because of the kind of gray area that this stuff may have fallen in beforehand, and not gray in a moral or ethical sense, but as to who has rights to a photo or video under certain circumstances, and then their rights to distribute it accordingly. So, for example, there was a point in time in which, say, the subject of a photo, at the time the photo was taken, consented to that, and then also knowingly and willingly shared that photo with their, intimate partner. The question for some time and in certain jurisdictions was, well, if that partner then shares that photo, what right does the subject of that photo, who gave it to the partner willingly, knowingly, fully consenting, and everything else, have to stop them from doing that? And these, as far as I understand, the state legislation, in particular in the 48 states that you mentioned, and maybe at the federal level, is just saying, no matter what, that's not going to be okay.
Yeah, it definitely depends on, it's a state-by-state basis. So there are states that have different thresholds, even to the extent of, describing what type of body parts are shown and what the images depict. But typically there is some sort of intent involved, some kind of a mens rea, where the person sharing the image either had the intent to harm, or if they didn't have that intent, they knew that this wasn't an image that was meant to be shared with others.
Okay, that makes a lot of sense. Mm-hmm.
And just to put a finer point on it, I'm sure that there have been more studies that have come out in the last 5 years, but I did find one from 2017, and this was through the Cyber Civil Rights Initiative. It found at that time 1 in 8 adult social media users reported being a victim of revenge porn.
1 in 8?
1 in 8. So you can only imagine, unfortunately, that number has probably increased. But this is also the purpose of this legislation. Now that almost every state and at the federal level, you have these protections, the hope is that there will be deterrence. And certainly we're getting better at tracking down IP addresses and finding out who is behind these images. Now, deep fake pornography is something we'll have to cover on a different show because I think we could spend a whole hour on that. But that presents a whole new problem for, what are the rights of these people where it looks like them, but it's not really them. I mean, we just saw that with Taylor Swift.
I was going to say Taylor Swift is actually leading the charge on that, as she so often does, right?
On all things, yes. So more on that.
A hacking group called Lockbit apparently has hacked the Fulton County, this is in Georgia, court website and made copies of sensitive sealed court documents related to the criminal case against former President Donald Trump, I think in other cases as well. It's threatening the court system to release those documents unless it gets paid a ransom. And I'm going to quote from a Business Insider article on the hack, quote, in a message posted online Saturday, this was 3 weeks ago, in both English and Russian, the hacking group called Lockbit 3.0 said the stolen documents contain a lot of interesting things in Donald Trump's court cases that could affect the upcoming U.S. election. Initially, Lockbit 3.0 set a Saturday, March 2nd deadline for payment, according to the cybersecurity reporter Christopher Krebs. It has since moved that deadline to 8:49 a.m. on Thursday, February 29th. Lockbit 3.0's restored website now shows, unquote. And I'm covering the story because Fulton County did not pay the ransom as of February 29th. And then the deadline was, again, moved back another week, and they still didn't pay. We'll talk about that in a moment, though. So this is part of me speculating here, but this is a criminal case. And wouldn't the unauthorized and, illegal disclosure of these types of documents, which are filed under seal and are heavily redacted and all those things, if they were leaked, wouldn't that seriously infringe on the criminal defendant's due process rights and really make it difficult to try them, given our procedural rules around that kind of thing? I think it's potentially grounds for, a mistrial, for example. If I was on the defense, I certainly would be considering that. And to my knowledge, this is the first time that a court system's document processing, saving, server, whatever you want to call it, process has been hacked. And it just makes me think of the amount of sensitive information that must be contained in this system just based on, our litigation experience, the types of things that get filed and attached as exhibits and all those things, oftentimes by people who don't file them under seal and just aren't expecting anyone to go look at them.
Right.
But if they actually did, it could be potentially damaging. But everything from financial statements to medical records, personal identifying information, all those things. A court system, online filing system is going to, it's going to be potentially a treasure trove of sensitive documentation and information. And seeing this now being targeted by these ransomware hacker groups, it just makes a lot of sense from their perspective. And it's a bit scary from my perspective. I think the implications for this hack broadly are pretty scary, but on the kind of Trump criminal case alone, which we're not going to get into the details of that, but I think it could seriously affect the ability of the state of Georgia to prosecute him. Imagine something that was going to be filed with the intention of never seeing the light of day of the jury. All of a sudden, it gets exposed to the jury pool. It's going to raise an endless amount of challenges to who gets impaneled on those juries and whether Mr. Trump gets a fair trial and all those things. I do want to talk about the most recent update on this story. This was as of about 2 weeks ago. As I mentioned earlier, Fulton County has refused to pay the ransom. And I'm relying now on a write-up from an outlet called State Scoop, which is actually a pretty cool website that tracks data security, AI, data analytics, stories, things like that. And according to that, as of I think it was early March, and I've looked and I haven't seen any updates since this, the Board of Commissions of Fulton County has refused to pay the ransom. And quoting from the piece, and this is the chair of the Board of Commissions, his name is Rob Pitts speaking, quote, "They could still release whatever data they have at any time, today, tomorrow, sometime in the future. We simply have no control over that," Pitts said in a news briefing, which was live streamed on the county's YouTube page, 4 p.m. local time. "We are monitoring the situation closely and will continue to work with law enforcement." Krebs on Security reported that on February 13th, Lockbit 3.0 posted samples of sensitive data from Fulton County in a new entry on its victim-shaming blog in an effort to force payment. Quote, "We will demonstrate how local structures negligently handled information protection," the hacking group wrote on its blog post. "We will reveal lists of individuals responsible for confidentiality. Documents marked as confidential will be made publicly available. We will show documents related to access to the state citizens' personal data. We aim to give maximum publicity to the situation. The documents will be of interest to many. Conscientious residents will bring order," unquote. I mean, it seems to me like the hackers aren't getting the juice from the squeeze that they expected here, and I think that's a good thing. And now they're kind of reframing this as being, white hat hackers, that they're hacking to demonstrate the vulnerabilities rather than to just squeeze out a ransom, which is BS, as we know. But good on Fulton County for not paying. It seems like seemingly everyone that gets hit with these types of data security ransomware attacks usually just pay the ransom, as far as I can tell. And for example, I'll go back to 2021, so it's a little bit outdated, but I think still relevant. Forbes reported that around 15% of all law firms globally showed signs of compromised networks. That's the terminology they use. I think even worse, in October of 2020, the ABA published something saying that a whopping 29% of law firms reported a security breach, with more than 1 in 5 saying they weren't sure if they'd even been compromised. So hopefully American firms have made progress in this regard in the 4 years since that data was published and collected. Going back to that State Scoop piece, I'm going to quote again. Quote, "The Cybersecurity and Infrastructure Security Agency advises against fulfilling ransomware payments as they do not guarantee that data obtained by hackers will no longer be compromised or lead to a restoration of services and data. Any ransom payment sent to a foreign hacker may also violate sanctions set up by the Office of Foreign Assets Control, according to a 2021 report by the U.S. Treasury Department." Unquote. That last bit is kind of interesting, especially in light of the Russian-Ukraine war and the fact that I think a lot of these hacking groups are at least affiliated with or associated with nation states and actors based in Russia, I think. So, cutting them a check for whatever the ransom might in fact actually get you in trouble. Something to think about. So if you're listening to this, take whatever steps you need to take. I don't know, because I'm not one of these lawyers and I'm not exactly the most tech-savvy person, but that's why we rely on experts to do that. And I would suggest that anyone at home who is hearing this and, maybe feeling concerned, do the same. One last thing, kind of the nature of these hacks targeting firms and now court systems. I touched on it before, but the level of sensitivity contained in a law firm, for example, much less a court system, is extremely high. And it's kind of an alternative target to, say a bank or a healthcare system, where they do have probably more robust cybersecurity infrastructure just based on the tighter regulatory controls. I mean, a healthcare system has been dealing with HIPAA, for example, for decades, right? Law firms, we have ethical obligations and we do our best, but I think anyone who's been around this has seen, solo litigation attorney attaching unredacted medical records to a motion, for example, and then that gets filed and the whole world can go read them if they want. I'll say that the delta of best practices is wider for maybe law firms than they are for banks or healthcare providers. So that's another way of saying I think that maybe these are considered juicy targets for these ransomware attacks, and I hope that everyone kind of tightens up.
So the issue of the jury pool being tainted is an interesting one, and definitely something that in First Amendment law we deal with a lot, because of course I'm probably more on the other side of it, where we want to have open access to documents. We want the public to know, for example, this comes up a lot with body camera footage. So even though there is a chance that a jury pool could be tainted by some of this stuff, you have to do that balancing act of making sure someone has a fair shake at a criminal trial, but also the right for the public to have the information and to have that oversight over its government. And it sounds like in this case that these are government documents, a lot of them, or generated by government. So.
Yeah, but I mean, they're already filed under seal or via redaction, or were sent for in-camera reviews. So like ostensibly, if there was an objection to it being sealed, that's already been litigated and adjudicated. Or oftentimes, as we know, the parties just agree. They'll say, hey, we're not going to put, for example, anything that has your client's social security number into a publicly filed document, right? That's like a pretty easy one. So you'll redact that.
Right.
Or, hey, we have to file these financial documents because the court needs to see them. The court can review them in camera, but we both understand that the public shouldn't see these things because that's not what this lawsuit is about, for example.
Right. Yeah, so I guess what I'm saying is there are, these issues come up a lot, and so the court does have systems in place to ensure that, even just voir dire, making sure that there are going to be jurors out there who have no idea about this story, have never read this issue and known that it's even come up. So even if documents were leaked, there are going to be people who haven't seen them. But I guess what I'm getting at is that I'm glad that the court didn't pay the ransom just for the sake of keeping these documents withheld or redacted or censored, however they were.
Yeah, good point for them. They're like, look, they can release it whenever they want, whether we pay them or not. You are negotiating with criminals who just stole something. Right. So, no honor amongst thieves. If you cut them a check, you're just crossing your fingers and hope that they don't come back to the well. And they could anytime. So, yeah, I think just kind of standing up to them and is the right thing here, and so be it if these documents come out and it affects the prosecution's ability to get this to trial or whatever. Right. What can you do?
Right. Well, and it could certainly set a dangerous precedent if you have courts starting to give in to this.
Ooh,
because,
yeah.
You think about all the high-profile cases across the country. Hackers could do this, in any number of situations. You've got cases against big corporations, Pfizer, Johnson & Johnson. I'm sure.
What about so let's say these documents get dumped into the public sphere, the defense successfully argues for, I don't know, maybe the documents get released mid-trial, they get a mistrial, or they make a procedural argument, one way or the other, basically get their client off. Wouldn't that create an interesting precedent for politically motivated hackers or privately funded hackers to just meddle with criminal proceedings so that prosecution under our procedural rules becomes impossible in a given case, whether it's Trump or anyone else. You could see a scenario where it's like, hey, let's cause so much mayhem in this system that this person who is being tried for XYZ crime cannot be tried.
Yeah.
Maybe I shouldn't have said that.
I was going to say, anyone listening,
Don't
earmuffs.
do that,
No, that is scary. And I just sitting here listening to this story scares me because I think as lawyers, we do the best we can. We protect documents. We trust in the court system that things are going to remain sealed. So now it's like, oh shoot, should I be asking for in-camera inspection on certain things?
On everything.
Yeah.
Yeah.
Instead of actually trusting that the court will, maintain these things in a sealed fashion.
And let's assume that Fulton County here is 100% acting in good faith and took what anyone would call reasonable precautions and still was hacked. I'm not implying that they weren't
sure,
that
right.
secure. I'm sure they probably were, right? I mean, that's everyone says that they are until they get hacked.
Right.
So yeah, it's. I think the broader implications of it are interesting. I think kind of on this one-off issue of what's going to happen in the Trump prosecution, that's just, kind of interesting and concerning for me, just as to what it says about private actors' ability to disrupt prosecution of anyone if they wanted to. And I just think that that's something that is. I don't even. Actually, by the way, it doesn't even seem like from the words and actions of the hackers here, Lockbit 3.0, that they've grasped that, because they would have to have probably a decent understanding of criminal procedure to realize that that's probably the bigger issue here than what they're claiming, which is to expose the public servants who didn't encrypt their files enough or whatever, which no one cares about.
Very interesting. All right, now, kind of on the same topic of Trump, but moving to a recent U.S. Supreme Court decision, they heard in expedited fashion arguments regarding the state's ability to remove presidential candidates from state ballots. So, quick background on this case. This was out of Colorado. There was a group of voters there, which interestingly were 4 registered Republicans and then 2 that were unaffiliated. They filed a petition against former President Trump and the Colorado Secretary of State, claiming that Trump was constitutionally ineligible to serve as president again and should be removed from the ballot. These voters, they relied on Section 3 of the 14th Amendment, which provides, in pertinent part, that no person shall be an elector of president under the United States who, having previously taken an oath as an officer of the United States to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. So their argument was that essentially Trump's participation in the January 6th insurrection disqualified him from holding office of the president again. Now, the Supreme Court of Colorado agreed with this and ordered that Trump be removed from the ballot, but that decision was stayed pending resolution at the U.S. Supreme Court level. Now, they took this up pretty quickly because obviously we're entering election season, so they had to render a decision because we actually saw here in Cook County that wasn't Trump removed from
I believe it was
the ballot
removed
initially.
from the Illinois ballot.
Yep. So other states were taking similar action. And so the Supreme Court jumped right on this issue. The decision that was published March 4th of 2024 was unanimous. So all justices agreed that Trump should remain on the ballot. While the states may disqualify people from holding office in the state, they don't have any power under the Constitution to enforce Section 3 with respect to federal offices. And I mean, this is just from a practical standpoint, it's pretty easy to see how state resolution on the qualification of a presidential candidate can lead to inconsistent results. You could have some states that are banning a certain candidate from their ballots while other states don't. And ultimately, the president represents the voters in the nation. So this is really an issue of federal law and oversight. Now, what's interesting about this case is that 4 of the justices expressed that the majority went too far in the decision that was published. So again, the issue before the court was whether a presidential candidate can be taken off the ballot by a state under Section 3 of the 14th Amendment. The resounding answer was no, but the majority opinion delved into other issues that weren't really before the court. And this was namely whether federal actors can enforce Section 3 and how they must do so. Now, conservative Justice Amy Coney Barrett, she was one of the justices that wrote a separate concurrence. However, hers was fairly short. And the other concurrence was drafted jointly by the liberal justices. So that's Sotomayor, Kagan, and Jackson. And this one was a little bit more aggressive in tone. Now, when the decision was published, that concurrence by the liberal justices, the metadata was not wiped from that document. And what the metadata actually revealed was that Justice Sotomayor was initially a partial dissenter, yet the opinion was published as a unanimous decision. So this led to a host of conspiracy theories why did SCOTUS put out this opinion as unanimous on this very hot button issue when it seems like potentially one of the justices disagreed and felt that maybe states could remove someone from a ballot? Now, an article from the American Bar Association explained that one way to see the metadata was as simple as taking the top portion of that concurrence, copy and pasting it, putting it into Word, and when you do that, it shows up that Sotomayor concurred in part and dissented in part. Apparently that same metadata showed up when you search for the word dissent. So the question is, what happened? Certainly this decision was rendered quickly by SCOTUS standards, so the failure to scrub this data was likely just an oversight in the rush to publish. But I guess the bigger question is, how did this lone dissenter transform into a concurrence and then become authored by all three of the liberal justices? So we have Paul Schiff-Berman, who is a professor at George Washington University of Law, weighing in on this. And it was his opinion that Sotomayor's opinion may have become a concurrence just in an attempt to emphasize that the justices were all on the same page on this very important issue. And this certainly makes sense because, as Justice Barrett noted in her concurrence, quote, "The court has settled a politically charged issue in the volatile season of a presidential election. Particularly in this circumstance, writings on the court should turn the national temperature down, not up. For present purposes, our differences are far less important than our unanimity. All 9 justices agree on the outcome of this case, and that is the message that Americans should take home," end quote. Now, an article by Slate offered further speculation as to why Justice Sotomayor may have changed her decision. One of the broader theories that they put out is that this could have been a bargain between the justices. So if they issued a unanimous opinion that Trump should stay on the ballot, then possibly they would refuse to take up Trump's separate dispute that he was immune from criminal prosecution. So in other words, they would allow Trump to run in all 50 states, but then he would also have to contend with a criminal trial prior to Election Day. Now, we know, as of the date of this airing, that bargain, if it ever in fact existed, didn't come to fruition because SCOTUS has granted certiorari and will hear argument in April on this issue of whether Trump is immune from criminal prosecution. But maybe that actually was the bargain. So it's possible that the court could have pushed that argument on Trump's immunity to the fall term, which definitely would have guaranteed that the election would proceed before a decision was rendered. But perhaps in exchange for a unanimous opinion on this issue, they decided to hear argument in April. Just another theory being thrown out.
Yeah, I mean, I think that the past couple years in particular, to anyone who's paid attention, and this is not a court-watching podcast, and neither one of us is practicing in front of the Supreme Court, but is people who are aware of our surroundings and pay attention to this type of thing. The idea of the Supreme Court justices as Justice Roberts, I think, put it, umpires calling balls and strikes, nonpartisan, non-political actors, I think has really taken a hit. I mean, there's this, of course, which seems in some way, I don't know if it was quid pro quo, we're going to take this case and not the other, but there was certainly some type of political calculus involved so that they could get a 9-0 opinion and, I think, protect the legitimacy of the court, which has, I think, been under popular scrutiny for the past couple of years. And to tell the public, look at us, we're actually not divided. We're united on this important issue, and that's why we're 9-0. And so to arrive at that conclusion would require someone who intended to dissent to be persuaded to change their mind. And that's just part of it. And I think anyone who has looked into the inner dealings of the court and all that stuff, I think Jeffrey Toobin's books on this stuff are decently good, notwithstanding all the other stuff Jeffrey Toobin has gotten involved in. But there is some element of horse trading and political negotiation among the justices. And I think that really that idea that they are nonpartisan actors, non-political, I think is, I hate to say it, but kind of somewhat naive these days. I mean, remember the Dobbs leak, right?
Mm-hmm.
Right.
That
was huge. And by the way, they never resolved that. That's another thing that's just out there.
Yeah.
We just don't know who did it or for what reason or to what end. I mean, so I think reaching a 9-0 conclusion or decision rather on this is like more important than the substance of the decision, and there is a pretty wide variety of reasonings offered among the 9 justices for their decision, and we could talk about that if in a moment. I think it's probably worth getting into, but ultimately I think the goal here was like, folks, we need to put on a united front here for the benefit of the public, not necessarily for the administration of justice, even though I ultimately, I think, agree with the outcome. But I don't think that's the reason why it's 9-0. And I think if you took 9 people off the street and asked them about this, I don't think you would get a unanimous decision from 9 people. I don't know why you would expect anything different from the justices, for example. So I think it's more of that. Ultimately, if you're paying attention, I think it further serves to hurt the legitimacy of the court when you have this type of thing leaked. Also, let me put on my tinfoil hat here. The metadata being included in what if it's the same person who leaked the Dobbs thing? Like it's some clerk there who's just putting out drafts and getting everyone in trouble, right?
I think clerks are limited to a 2-year term at the Supreme Court level.
I have no idea.
I may have just pulled that out of nowhere, but that was like deep in the memory bank from somewhere.
Sure.
So we'll go with that.
Someone is screwing up at like a document management level up there, and it just so happens to be on like 2 of the most important things that the public is worried about for the past couple of years. I don't know, man. Maybe the mole is still active. Sounds like another conspiracy theory, Jack. For a minute, can you indulge me on Section 3 of the 14th Amendment?
Yeah, of course.
Okay. And my ongoing threat to pull the rug out from under the show and turn it into a Civil War podcast, I have to, again, make clear to the listeners that I'm going to do it one of these days. I think ultimately the decision here and it practically makes a ton of sense. You can't have different states saying, this person can be on, this person can't be on. Like it really just screws with the federal election in a way that makes it unworkable. So figure out a way to make sure that doesn't happen. I will say though that the reasoning given by some of the conservative justices, I don't think necessarily addresses some of the arguments that were made at the Colorado Supreme Court level, and which ultimately the Colorado justices in this case relied on. I don't necessarily think they're persuasive, but I think they're worth mentioning. For example, this idea of the federal government is the final say on whether you can be listed on a state election form or whatever. There are a lot of instances where states are intervening and adjudicating federal requirements for candidacy on the ballot.
For federal candidates?
Yeah. So, for example, if you're not 35 years old, right, you can't be president.
Yeah.
So state courts deal with that often, all over the country. So, if you want to put in and file the paperwork to run for president when you're 12 years old, a state court will tell you no, or can tell you no. And there's like plenty of examples of that. That's a constitutional requirement. It's not in the 14th Amendment, but the rule for nationalized citizens also gets adjudicated at the state level. So a hard and fast rule that only federal courts can adjudicate these issues, which is not exactly what they said in the Supreme Court opinion, but that's what I think people have taken away from it. Mm-hmm. It's just not the case, right? State courts are adjudicating eligibility requirements for the office of presidency, for example. It was specific to this Section 3 of the 14th Amendment, the part that deals with quote-unquote insurrections, which is not defined by the 14th Amendment,
right,
or this subsection, and was passed in the wake of the Civil War, where everyone sort of knew what they meant. And I think that it's a little tedious when the originalists on the court pretend like they have no clue what this word means in certain circumstances, and shy away from going, oh, well, what, we don't know, it's not in there, so how can we possibly interpret it, when they do that for everything else. So that's my 2 cents on that. I think the collective playing dumb on some of these opinions when it comes to the Civil War amendments, and versus we know exactly what Thomas Jefferson was thinking when he wrote the Bill of Rights, does just kind of annoy me.
Yeah, so just for the listeners, what the Supreme Court says about this Section 3 and when it was passed, quote, "It was designed to help ensure an enduring union by preventing former Confederates from returning to power in the aftermath of the Civil War." So that was their intent behind this Section 3 of the amendment.
Sure, and they shy away from actually deciding the issue of like, was this or was this not insurrection, on the grounds of, well, it's not in the amendment, so we have to look to later congressional acts which define it in different contexts. And I think I want to say that the first loosely called Insurrection Act was passed in the 1870s. But there are interim periods where the President of the United States could unilaterally declare an insurrection and invoke insurrection powers of the executive, for example. So there are non-congressional ways of defining this topic that I think proponents of President Trump's arguments at the Colorado Supreme Court level forgot or did not mention or shied away from. And I just I would like to give the framers of the post-Civil War amendments the respect they deserve. I'll put it that way.
That's fair. Well, certainly either way, this intermingling of politics in our current Supreme Court is equally interesting and terrifying. So I'm sure we'll be covering more on this subject. That is our show for today. Definitely join us in 2 weeks when we come out with our next show. You can follow us on Apple, Spotify, or wherever you get your podcasts. Be sure to like and subscribe, and also add some comments. Let us know what you think of the show, any questions you may have, topics you want to hear in the future. And that's it for now.
Thanks, everyone.